unanimously and clarified some of these issues. Yet I believe that the bill is right in line with the opinion, and look forward to you supporting 4851.
Okay, very good. The only thing I can think of off the top of my head is the Senate has already voted that caregivers cannot be felons. There were only 2 votes against it. So that probably most likely would be an addition to all of your work, but we certainly, the feeling is if we do have somebody who's a senior in the last stages of their life, we don't want a felon going into their home to deliver marijuana, whether it be a thief. Certainly we wouldn't want a rapist or anybody else in there that was could harm the or steal from the senior. So that might be something that we would work on. Other than that, we're going to take additional testimony, and I hope by this fall we can complete the work. Thank you for coming over. Do you have any questions?
Thank you, Mr. Chair. We are available today and beyond for any questions you might have.
Thank you.
Thank you.
Okay, now, Madam Clerk, please call the roll to establish quorum.
Senator Jones.
Here.
Senator Shoemaker. Senator Rocca. Here. Senator Bida. Mr. Chair, you have 3 members present, a quorum.
Very good. We're going to be taking up a number of bills today. 1126, 1127, 5431, 3233, 743, 5124, 5658, 5560, and we'll be taking further testimony on the medical marijuana. Senator Shoemaker moves to adopt the minutes from June 5th, 2012 with unanimous consent. Without any objections, the minutes are adopted. We're now going to turn to Senate Bills 1126 and 1127. I have a card turned in today from Dusty Fancher of 3M Electronic Monitoring, supports the bill. As you recall from last week, we took testimony. Senate Bill 1126 would require that a felon on work or school release wear an electronic monitoring device while on release. The inmate would be responsible for the cost of the operation of this device. This bill would only apply to counties or courts that have the ability to outfit an inmate with a tethering device. Senate Bill 1127 would require that the inmate convicted of the felony has their work or school verified within 7 days before release. So we ensure that they actually have a job. We've had way too many cases of people going out on work release, committing crimes, going to the bar, going wherever, and not actually going to work or school. It's hope that these bills would take care of that problem and at least go a great length at taking care of them. Are there any questions? Seeing no questions, I make a motion to adopt the S1 substitute to Senate Bill 1126. Madam Clerk, please call the roll.
Senator Jones.
Yes.
Senator Shoemaker. Yes. Senator Rocca. Yes. Senator Bida. Yes. Mr. Chair, you have 4 yeas and 0 nays.
The substitute is adopted. I move to report Senate Bill 1126 S1 with recommendation the bill then pass. Madam Clerk, please call the roll.
Senator Jones.
Yes.
Senator Shoemaker. Yes. Senator Rocca. Yes. Senator Bida.
Yes.
Mr. Chair, you have 4 yeas and 0 nays.
Bill is reported. I move to recommend immediate effect. Seeing no objection, the committee will recommend immediate effect. May I have a motion to adopt the S1 substitute to Senate Bill 1127?
So moved.
Senator Bida moves to adopt the S1 substitute. Madam Clerk, please call the roll.
Senator Jones.
Yes.
Senator Shoemaker. Senator Rocca. Yes. Senator Bida.
Yes.
Mr. Chair, you have 4 yeas and 0 nays.
Substitute is adopted. May I have a motion to report Senate Bill 1127 S1 with the recommendation the bill then pass?
So moved.
Senator Bida moves to report Senate Bill 1127 S1 with recommendation. Madam Clerk, please call the roll.
Senator Jones.
Yes.
Senator Shoemaker. Senator Rocca. Yes. Senator Bida.
Yes.
Mr. Chair, you have 4 yeas and 0 nays.
Bill is reported. Senator Bida moves to recommend immediate effect. Without any objection, the committee will recommend immediate effect. We'll now take up House Bills 5431, 3233. See, we have no further cards turned in today. We took testimony on the bills last week. And may I have a motion to adopt the S2 substitute to House Bill 5431? I will move to adopt the S2 substitute. Madam Clerk, please call the roll.
Senator Jones?
Yes.
Senator Shoemaker? Yes. Senator Rocca? Yes. Senator Beta?
Yes.
Mr. Chair, you have 4 yeas and 0 nays.
Substitute is adopted. I'll move to report House Bill 5431 S2 with recommendation the bill then pass. Madam Clerk, please call the roll.
Senator Jones?
Yes.
Senator Shoemaker? Yes. Senator Rocca? Yes. Senator Beta?
Yes.
Mr. Chair, you have 4 yeas and 0 nays.
The bill is reported. I move to recommend immediate effect. Seeing no objection, the committee will recommend immediate effect. We'll now take up House Bill 5432. I move to adopt the S1 substitute to House Bill 5432. Madam Clerk, please call the roll.
Senator Jones?
Yes.
Senator Shoemaker? Yes. Senator Rocca? Yes. Senator Beta?
Yes.
Mr. Chair, you have 4 yeas and 0 nays.
Substitute is adopted. I move to report House Bill 5432 S1 with recommendation the bill then pass. Madam Clerk, please call the roll.
Senator Jones?
Yes.
Senator Shoemaker? Yes. Senator Rocca? Yes. Senator Beta?
Yes.
Mr. Chair, you have 4 yeas and 0 nays.
The bill is reported. I move to recommend immediate effect. Seeing no objection, the committee will recommend immediate effect. We'll now take up 5433. Again, we have a S2 substitute.
Move to adopt the S2 substitute.
Senator Beta moves to adopt the S2 substitute. Madam Clerk, please call the roll.
Senator Jones?
Yes.
Senator Shoemaker? Yes. Senator Rocca? Yes. Senator Beta?
Yes.
Mr. Chair, you have 4 yeas and 0 nays.
Substitute is adopted. May I have a motion to report House Bill 5433 S2 with recommendation the bill then pass? I will move to report House Bill 5433 S2 with recommendation. Madam Clerk, please call the roll.
Senator Jones?
Yes.
Senator Shoemaker?
Yes.
Senator Rocca? Yes. Senator Beta?
Yes.
Mr. Chair, you have 4 yeas and 0 nays.
The bill is reported. I move to recommend immediate effect. Seeing no objection, the committee will recommend immediate effect. We'll now take up Senate Bill 743. Again, we've taken testimony on this previously. The Uniform Child Abduction Prevention Act is intended to prevent the abduction of children by establishing standards for determining whether a child is at risk for abduction and providing remedies to prevent it. The act empowers the judges to order abduction prevention measures in child custody proceedings upon a finding that the evidence establishes a credible risk of child custody abduction. Proceedings could be for protection from domestic violence, divorce, abuse, neglect, dependency, paternity, termination of parental rights, and guardianship. Purpose of this legislation is to protect children from abduction when a judge sees a pattern that would put them in jeopardy. I have a card in support of the bill from Bill Candler, the Family Law Section of the State Bar.
That was very convincing, Mr. Chairman. I'll make a motion to adopt the S2.
Very good. Motion made to adopt the S2 substitute. Madam Clerk, please call the roll.
Senator Jones?
Yes.
Senator Shoemaker? Senator Rocca? Yes. Senator Beta?
Yes.
Mr. Chair, you have 4 yeas and 0 nays.
Substitute is adopted. Senator Beta moves to report Senate Bill 743 S2 with recommendation the bill then pass. Madam Clerk, please call the roll.
Senator Jones?
Yes.
Senator Shoemaker? Yes. Senator Rocca? Yes. Senator Beta?
Yes.
Mr. Chair, you have 4 yeas and 0 nays.
Bill is reported. Senator Beta recommends immediate effect. Makes that motion. I see no objection. Committee will recommend immediate effect. We will now take up House Bill 5560, Representative Deb Shaughnessy. Now, this bill is exactly the same as Senate Bill 19 that passed through the committee. It would increase the penalty for disrupting religious service to 90-day misdemeanor with a maximum fine of $1,000 or 100 hours of community service. For the second offense, it would increase the penalty to $5,000 fine or 200 hours of community service. Representative Shaughnessy were involved in this issue. We had 20 people invade a church, disrupt the service, pulling fire alarms, screaming at members of the church. We have a country where people have the freedom of religion, and we simply cannot have anybody disrupting religious services. This will protect church, synagogue, a mosque, all religions. That's the intent. This had a great deal of bipartisan support in the Senate and the House. And I will now move House Bill 5560 with the recommendation the bill then pass. Madam Clerk, please call the roll.
Senator Jones?
Yes.
Senator Shoemaker? Yes. Senator Rocca? Yes. Senator Beta?
Yes.
Mr. Chair, you have 4 yeas and 0 nays.
The bill is reported. I move to recommend immediate effect. Seeing no objection, the committee will recommend immediate effect. We'll now take up House Bill 5658. Representative Haveman, would you like to come up?
Thank you, Mr. Chairman. Thank you, committee, for allowing us to be here. With me today is Jessica Peterson with the Department of Corrections. I'm going to be brief because Jessica is the expert and I have to get off to House session. But in a nutshell, House Bill 5658 clarifies the use of inmate labor if it is assigned to a private vendor inside the prison. Currently, our prisoners make a much less than minimum wage for tasks that they do within the prison, such as food service is probably the best example. This would allow the department, if it chooses to privatize a function for service within the prison, to pay the same prisoner for doing the same job, the same amount of money. Currently, the way the statute is, if a private company came in and can manage these services within the prison, the prisoners would have to receive minimum wage or possibly even prevailing wage. This would correct that.
I think the representative covered most of it. I think one thing I just want to reiterate is this bill is just ensuring that we maintain the status quo in terms of the pay scale that our inmates currently receive.
Very good. Do we have any questions? Seeing none, I just would state that as a former jail administrator and as a former sheriff, I had inmates that were happy to work for nothing. So I certainly think that minimum wage is inappropriate for what you're talking about, and appreciate your work. Thank you. I would now invite Nick, I'm going to mispronounce this, Ciarameto.
If you pronounce it correctly, you know there's something wrong.
Okay, of ASME and MSCA, and invite you to come up and speak. He opposes the bill.
Thank you, Mr. Chairman. Michigan AFSME, for the record, my name is Nick Shomatero, and I am Director of Legislation and Public Policy for Michigan AFSME and for the Michigan State Employees Association. You've had the bill described to you, but I think you need to know that our opposition is based on several concerns. One concern is that the jobs of supervising these inmates, and this is one of the issues, is whether or not this should be done by in-house staff or by private vendors, is an extremely dangerous job. Our inmates, our food service workers supervise inmates in the kitchen, which means they're dealing with cutlery, which means they're dealing with things that can become weapons. So an issue that we have to take into consideration as we go forward is whether or not we're going to jeopardize the danger to the inmates and to the staff. That's also true of inmates who are used for storekeeping operations, et cetera, where MSCA represents employees there. In fact, that job's so dangerous that the last person that was killed in the prison was actually a storekeeper. We're also concerned about let me give you a little history of how we got to where we are and why we require minimum wage for these types of positions. If you go back to probably the 19th century when this provision actually went into place, there was a concern, and I think rightfully so, that we should not be allowing one company to compete with another company by allowing them to use a cheaper labor source, that is inmate labor, at very reduced wages in competition with other businesses that have to pay minimum wage or prevailing wage. We believe this will alter that dynamic, and it alters that dynamic even though it only allows this use when the prisoners are working in the facility to provide their own services. Several years ago, probably now about 25 years ago, I was a member of the House at the time, we extended this law and said not only do we have to pay these folks minimum wage so there's competition, but that they can't work on anything that competes with an outside business in the state of Michigan. And that was because they were only being paid minimum wage, where the people outside may be substantially more, and because of the unfair competition that would create because they're tax exempt and so forth, and because the business is tax exempt. What this does is it limits it only to people inside the prison, and that's a good thing. But we believe that that creates unfair competition nonetheless. If a business is creating or dealing with products that are used in the prison, they can come in and at minimum wage, at sub-minimum wage, at a few cents an hour, pay prisoners to do that work. But that money translates, may or may not translate into some savings. The state doesn't translate any new savings because that's what we're doing now with our own supervision, but translates into profits for that business, and that money is fungible. So the result would be the concept that says we can't have in-prison labor competing and tax-exempt businesses competing with businesses outside of the facility goes away if the same company is producing some products where they're paying some minimum wage inside the facility and some products where they are paying minimum wage outside of the facility, because the money is simply fungible, it's transferable. So we believe that if we altered this law, the intent of the sponsor and the maker of the bill is to bring in folks who are not properly trained to supervise dangerous criminals. You had some of those in the jails that you supervised, Mr. Chairman, but not to the level that we have inside the prisons. I remember my sheriff in Macomb County, when I helped him get a contract that took some state prisoners, complained to me later that we were sending him mean people to his prison, and I said, well, we don't really put nice people in our state prisons. So this is a more dangerous population. Our supervisory personnel, the in-house Department of Correction personnel, are trained as guards. They are not just business people coming in to do supervised, normal, if you will, employees, but they're trained as guards because of the potential danger with the serious potential weapons they're dealing with. We think that would alter that. It would create an unsafe condition inside the prisons. It would create an unsafe condition for both the prisoners and for the employees, and it would create unfair competition for some businesses. So for both of those reasons, we would urge you not to pass the bill as is. Thank you for your time, and I'll be happy to answer any questions if there are any.
You know, I think quite some time ago, we stopped calling them guards and turnkeys, and we call them professional corrections officers.
Corrections officers. But we give them the same training as correction officers. Okay. Yes, I stand corrected, Mr. Chairman.
And you know that the jails do have the same people.
Yeah, not in the same intensity or magnitude, because I was an assistant prosecutor. I know that you do hold those people in the jails awaiting trial, so they're the same people, obviously, but they're kind of diluted, if you will, by the misdemeanants who are in the prison and by others who are actually not even guilty, where in the correctional institutions we're dealing with only felons and only serious felons, and in many cases only dangerous felons. So I agree there's danger in the jails.
As far as the, I do agree with you that when the inmates work in the kitchen, that there are knives there. They're necessary to prepare food. And, but I can tell you from my experience as a jail administrator, I had a cook who was literally 71 years old, I believe about 4'11", maybe 4'10", and she was in charge of some 15 inmates, maybe more, never had any problem. So it is possible.
It may be possible, but I think it's a serious liability problem and a serious safety problem.
And so before those inmates were allowed to leave the kitchen area, all the knives were returned, they were locked up and counted, so a knife never came up missing.
I'm less concerned about them leaving the facility, because I think that's true, but we have seen instances, and that's why our food service people are required to be trained as correction officers, and why when we experimented once before with privatization in food service in a prison, and we actually did do it about 15 years ago, because of the increased security costs we had to incur by bringing in additional correctional officers, and because quite frankly, our folks have now got food costs down to less than $2 a day, and I don't know that you can get much better cost than that to feed a grown man 3 meals and a snack a day at $2. I keep telling them they should come over and teach me how to do that. My family would appreciate that information. But the food costs are down. The problem is, I think, because of those increased security costs, the price of the food service in that one prison where we experimented with it tripled in 1 year. And the result was that it came back into the in-state system. That's
Very good. Do we have any questions? Seeing none, thank you.
Thank you.
I have Mike McGrin, the Michigan State Employees Association, does not wish to speak, opposes the bill. Donna Spenner of MSCA, opposes the bill, does not wish to speak. We have the Attorney General's office here if needed for any questions. Do we have any further questions? Senator Bida.
Well, that's an open door when you ask for any questions on that. If somebody from the Attorney General's office is available for questions?
Yes. James Long?
Oh, okay. Is it possible?
James Long, please come up and answer questions. Thank you. Go ahead and proceed, Senator.
We heard a couple questions about liability. Does the AG's office have a position on that? Does this increase the state's liability?
I think those issues would be handled in the request for proposal, the RFP, which would go out and set the parameters for the training of the staff, the food service staff. What I think the previous speaker was talking about was his concerns about food service, and indeed that's what I think the Department of Corrections is contemplating, issuing an RFP to privatize food service. Right now, the prisoners work in food service with MDOC staff, and so they would be doing the exact same job, only for a private contractor, and it would be, if the contractor got the contract, it would be a substantial savings to the state. So the private contractor, the private employer, to the extent they engage in inappropriate conduct as it relates to the prisoners, they would be liable for that. You know, the suit would be brought against that entity.
Quick follow-up question?
As a practical matter, though, even if you had something in there to reimburse them, and if they became sued, the state would still get sued, even though there's a mechanism in there for the private contractor to take care of it. So you're still going to deal with some expenses from the state's position, I would
Yeah, and I guess my response to that would be anybody can sue anybody. That's right. So there's nothing that I'm aware of that could prevent anyone from suing the state. Now, whether there's merit to that suit or not is something else, but right, I will concede that anybody could sue.
Okay, thank you.
Thank you very much. May I have a motion to report House Bill 5658 with a recommendation the bill then pass? Senator Shoemaker moves to report House Bill 5658 with a recommendation the bill then pass. Madam Clerk, call the roll.
Senator Jones?
Yes.
Senator Shoemaker? Yes. Senator Rocca? Yes. Senator Bida?
No.
Mr. Chair, you have 3 yeas and 1 nay.
The bill is reported. Senator Shoemaker moves to recommend immediate effect. Seeing no objection, the committee will recommend immediate effect. We will now take testimony on House Bill 5124. Representative Cotter or staff? We have Chad Shoemaker of SCAO. Representative Connor, I just was notified, is tied up in session, so I'd like you to talk about this bill, please.
Thank you, Chairman Jones. I'm Chad Smucker. I'm the State Court Administrator. We support this bill. What this bill does is this modifies concurrent jurisdiction. I say modify. We already
expanding it and making it easier to achieve. What concurrent jurisdiction does is we have three different types of courts: circuit, district, and probate. There are certain things that a circuit judge can do, different things that a district judge can do, and different things that a probate judge can do. With a concurrent jurisdiction plan, they can share a variety of different duties that they have. This makes courts more efficient. It improves service to the public. It often saves money. This makes two changes. It broadens what they can share. There are limits right now on the types of cases that they can share. This broadens it, so there's more cases, will achieve more efficiency. Also, it makes it easier to achieve. The current requirement is that a majority of each bench approve a concurrent jurisdiction plan. Senator Jones, you're from Eaton County. There are 5 judges there. To have a majority of each bench, it means 100%, because there's 2 circuit judges. A majority of 2 is 2. A majority of 2 district judges is 2, and a majority of 1 is 1. So you have to have 100% of the judges in favor of a plan for it to be adopted. This allows a majority of the judges to adopt it. So 3 judges could approve a local plan. Some people are concerned about this, and they say, well, this would allow those 3 to adopt a plan that is unfair to the other 2. And that's a concern, but there's a safeguard in there that any plan that is approved locally still has to be approved by the SCAO and the Supreme Court. So this is going to make it easier to achieve. It's going to broaden what they can do. We think it's going to improve public service, and that's why we support this bill. I'd be happy to answer any questions that you have about this.
Yes, Mr. Smucker, I'm sorry I read it fast. I see a little different spelling there.
It's okay.
Do you have any questions? Yeah. Thank you for your testimony.
Thank you.
I have a card from Matthew Snyder, Michigan Supreme Court, supports the bill. I have a card from Cammie Pendle, Michigan Judges Association, supports the H4 substitute. Okay, we're going to work on this a little more with hopes of voting it out in July. Thank you. We will now continue with the medical marijuana testimony. And I have a number of cards, so please keep it brief as possible. I have Ken Stecker from the Prosecuting Attorney Association is here, available for questions on the recent court ruling. Ray Ramsdell of Lara is neutral on the bill, and Ray, do you wish to speak? And Vicki O'Brien of Lara.
O'Brien.
Wow, that's Mike. That's good.
All right,
Thank you, Mike.
I'm not even a medical doctor.
I'm just not good at reading your doctor's signature.
Exactly. Thank you, Mr. Chairman, members of the committee. My name is Mike O'Brien. I'm legislative liaison for the Department of Licensing and Regulatory Affairs, and with me today is Ray Ramsdell, the Director of the Bureau of Health Professions within LARA. That bureau oversees the medical marijuana program. I just want to speak very briefly and turn it over to Ray to talk. One issue I wanted to highlight for the committee is on page 7, at the bottom of page 7 of the bill. It talks about privatization of the program to issue medical marijuana cards. Understanding that at the time the bill was introduced, there was a huge backlog on processing these applications and getting cards issued. At the time, the backlog was probably 6 months. Since the printer that the department has finally got acquired and online, the backlog has been reduced to basically 2 to 3 day turnaround since the time that the application is approved. And when we look at that language, we understand that privatization, when it can save money from government services, is absolutely critical for taxpayers. What we don't want is to have to contract with any outside vendor to assist in a program if we're doing it as efficiently as possible. We agree with the use of photographs. That's a great law enforcement tool, anti-fraud tool. We're exploring with Secretary of State, possibly being able to use the photographs on file there and incorporate those. So there's consistency between the photo IDs that someone may provide for their MMP card and their driver's license card.
We'd suggest to the committee to change the language, hopefully, to take away the mandatory contracting with the vendor, authorize the department, if it's prudent, fiscally prudent, to enter into a contract with the vendor if some problem comes up in the future. We don't anticipate that. We think that we're on track to be able to implement this just fine without that. We just don't want to have any inadvertent obligation to contract if there isn't going to be a savings to the taxpayers. So that's on the bottom of page 7, starting on line 23.
Okay.
Ray has a couple of other ideas or issues that she's identified in the bill, and we'd hope, if the opportunity is there, to work with the committee and the chair and the sponsor in getting some of these addressed as well. Thank you.
Very good, thank you. Any questions? Seeing none, thank you. Sorry, you ready to add more?
I just wanted to add a couple of things. I wanted to say that we are very proud that we have caught up with our cards. We have printed over 100,000 cards since March, so we really have worked very diligently to get that caught up. We are in the final stages of identifying the panel for the petitions to add medical conditions. We have confirmed 10 members, and we'll be finalizing the last 5 members. We are hoping to work with the sponsors of this legislation to try to clarify some of the concerns or the questions that we have about implementation of some of the language.
Very good. See no further questions. Late question here. Steve.
I'm sorry, Mr. Chairman. And I apologize, I've been bouncing back and forth because I've got multiple committee meetings right now, too. Real quick question. You made a statement about you're catching up on the cards right now, and then that's good news.
We are caught up.
Are you totally caught up? Or
yes, we are totally caught up.
Okay, I didn't catch that part.
Cards are printed the day after. Typically, they're printed the day after they're processed. Or sometimes we'll hold a bigger batch and print within 2 or 3 days. But they are printed within 3 days maximum of being processed.
As just an issue of curiosity, what do the cards look like? Are they like the driver's license type of card, or?
They're more like a credit card.
Or like a credit
and there are
card.
holograph security on the credit cards.
Oh, we got a couple people putting the cards up in the back there. So, all right. I can't see it from here, but maybe after a committee I could take a look at it. I do appreciate that. I have not seen them yet, and I was curious what they looked like. So thank you.
Thank you. I'll now invite up Tim Beck, Coalition for a Safer Detroit. Supports the bills, wishes to speak.
Thank you, Senator Jones. Good to be back here again. I'm here to support the bills, not because I believe that the bills are absolutely picture perfect. I support them because I honor the legislative process that produced these bills. It was an honest process. It was open to everyone. Representative Walsh, Representative Horn, Representative Kavanaugh did yeoman's work. They spent hours and hours and hours learning about this subject. And the reality was a bill that, again, there's plenty of people in the room that are going to tell you what's all wrong with them, all right? But let me say this. I think, on the whole, the process was productive. The process worked. I just, maybe just less than 30 seconds to introduce myself more explicitly. You know, I'm probably, you do a Google search, Tim Beck, marijuana, all right? And you'll see that I was more than any one person in the state of Michigan probably responsible for this law, you know, being passed by the voters. And again, I'm not here. I don't think medical marijuana is the answer. My core belief is that the only solution to the so-called marijuana problem in this state, in this country, is some form of legalization and regulation and so on. And the Coalition for Safer Detroit, I'm pleased to say, won a 2-year court battle. The state Supreme Court ruled that the city of Detroit has to put a ballot initiative on the ballot in the city of Detroit, amending the city code, making possession and use of an ounce or less of marijuana on private property by anyone who has attained the age of 21 years on the ballot in November. I'm pleased. So those are my credentials. But again, as I say, I'm an American and I honor the process. And one of the things that has poisoned this country and poisoned the politics is this mentality over the last few years of, you know, winner take all, zero-sum game, scorched earth, the hell with you, no compromise, and that kind of thing. This was not what these bills were about. And I you know, again, if you see fit to honor what other people don't like, I'm fine with that. But on the whole, I think this was a good, honest process, and I would strongly recommend your unanimous reporting out of these bills, unchanged. Okay, thank you very much.
Very good. Seeing no questions, thank you. If Gershon Avery, a patient, opposes the bill and wishes to speak.
My name is Gershon Avery. I'm a cancer patient, specifically bladder cancer. My last surgery was Friday. Came home from that, started to mow the lawn, and then figured out I should read the instructions that said lay down on your back. You're supposed to be in the hospital for about 4 days. That'd be about today. I'm one of the people across the state that is using extracts of cannabis for chemotherapy to dissolve tumors in my bladder. I've successfully done that a couple of times. I brought along the CT scan discs if you'd like to take a look. This one I didn't catch, so they took it out anyways. I argue with the doctor, but I'm not going to say, no, don't go in there and cut it out. But I really think that I can get rid of them all, given enough time. These materials need to be explored by our doctors and by our universities, etc. Quite frankly, all of these bills target me. I'm a target because I'm a medical marijuana patient. I don't look sick. These target me. I don't know why. Am I a danger to society because I'm sick? I got cancer. I'm trying to kill it with cannabis. Thank you.
Thank you for coming in. I appreciate your coming in.
You're welcome. Hopefully I didn't bust out any stitches.
Daniel Solano? Opposes the bill and wishes to speak.
Senators, thank you for having me. My name is Daniel Solano. I'm a veteran of the United States Marine Corps. I'm a retired Detroit police officer, and I oppose House Bills 4834, 4851, 4853, and 4856. The proposed legislation does nothing to improve the Michigan Medical Marijuana Act of 2008. It does, however, place more burden on patients and caregivers to comply with the law. Michigan voters overwhelmingly approved this act. Currently, over 100,000 people are being kept out of the illegal market. They are now patients and they have caregivers. So that's keeping them off the streets. It's keeping them away from arrest, rip-offs, and exploitation. Among those protected are many veterans who are returning from combat tours in both Iraq and Afghanistan. Many have suffered horrific injuries and use medical marijuana to improve their quality of life and alleviate their pain. The proposed House bills have the potential to place our veterans directly back in the line of fire. In the past year, there have been several high-profile cases of either police officers killing a veteran or a veteran killing police officers because of marijuana violations, and I've attached some examples of that. My opposition to these bills as follows. For House Bills 4834, this allows local and state officials and officers access to the marijuana registry database via the lien system. The unfettered access to patients' medical information by any official or officer without a warrant is a recipe for abuse. Among those with access to the lien system are mall and hospital security guards. Throughout the last decade, there have been numerous cases of law enforcement abusing the lien system, and I've attached some examples. Not only does the proposed House Bill 4834 allow for abuse, it also allows for fishing expeditions by unethical officials, police officers, mall and hospital security guards. Michigan medical marijuana patients deserve a semblance of medical confidentiality. And then Bill 4851. This bill again would place more restrictions on patients and more hardships and restrictions on patients who do not live in a major metropolitan area. And this is dealing with the doctor-patient relationship. Not everybody has a doctor that they can go to. Not everybody is in an HMO. And even the HMOs, our doctors don't write the recommendations. I had to find a pain doctor separate of my HMO. I've had over 14 surgeries, and he wouldn't write me a recommendation, my regular doctor, because his organization said don't do it. So it forced me to go elsewhere, which fortunately I found a great doctor. But point on that is not everybody has these luxuries. So a lot of patients are being forced to deal with the clinics and forced to deal with doctors that aren't there all the time. But that's our reality right now. And the other thing about 4851, it puts limits on how a patient can transport live marijuana plants. Currently, this legislation says that it can only be the patient or the caregiver that transport these cannabis plants. The problem with that is a lot of patients are taking care of themselves, and sometimes we can't drive. Sometimes I'm not physically able to drive, so someone has to drive for me. And I'm a lucky one because I can walk still. I can run a little bit. I can still go to the gym. But many of my friends are in walkers, they're in wheelchairs. They don't have this luxury. So this bill would make it so that we wouldn't be able to get our plants if we weren't able to drive. And so that's absurd. So in that sense, I oppose that one because we do need to be able to get transportation besides yourself. Okay, now I'll go on. House Bill 4853, it's redundant. It's already a felony to sell medical marijuana to someone without a valid Michigan medical marijuana card. And then finally, House Bill 4856, the proposed legislation places another burden on patients and caregivers, requiring patients and caregivers to lock up their medication for transportation as if it were a firearm is both unnecessary and mean-spirited. Far more dangerous drugs do not require their containment in a sealed locked vessel while being transported. House Bill 4856 would only ensure more patients and caregivers become entangled in the legal system. That is something that patients, caregivers, and the state of Michigan cannot afford. Just please vote no on this proposed legislation. Thank you.
Thank you for your testimony, sir. I will double check, but unless something has changed, security guards, people like that do not have access to the lien system.
They do, sir.
And there are a number of police officers that have been caught inappropriately using it, and they've been fired and charged for the crime.
I'm aware how it works, sir. Yes, sir.
All right. Thank you, sir.
Thank you.
Richard C. Clement of the Michigan Normal Organization poses the bill.
Good afternoon, Senator Jones. Hello. My name is Richard Clement, and I am a member of Michigan Normal. That's the National Organization for the Reform of Marijuana Laws. I've been emailing you guys my comments about the bill, and it's nice to see you guys in person. As you know, I'm all about protecting children, and I noticed that you had some legislation. I'm speaking about House Bill 4856, but I want to speak about the K2 versus marijuana legislation that you're trying to push through. I support you on that. The kids honestly would be better off smoking real weed, although I don't support them smoking any weed, okay? If you had to take the worst of the worst, okay? My concern with House Bill 4856 is a cash cow and a tax at the expense of medical marijuana patients, okay? The end result of the bill is finances public libraries for every arrest that you make. So what's going to happen is that you have people in certain counties, maybe up in Kalamazoo, enforcing the law one way, versus somebody in Wayne, Genesee County enforcing it another way. It's going to invite what we call protective searches and searches of vehicles. You know, it's just it's an instrument for abuse. It's an instrument for abuse. And speaking of the real deal, it talks about impairment. That's what the general, you can't smoke while you drive and stuff like that. I think that's where you're going with it. I know, well, I'm not endorsing it, but people, you know, there's no logical test, no test to compare the difference between being under the influence of alcohol, being under the influence of marijuana, and actually driving a car. So what I would propose is that you get use a state police test track, and you get a couple state employees and a couple patients and run some statistical tests on, you know, what is impairment to end that discussion. Okay, that'll stop a lot of that. The bona fide relationship bill is going to be a waste because we have electronic medical records, okay? What is a bona fide relationship? Let's say I move away. Do I know this doctor? I need my scripts from other meds. I think that's functionally, it's just an overkill, in my opinion. I'm glad for the affirmative enclosed lock facility and outdoor growing. I think we should use natural light. I think we have a great university, Michigan State University, where we can use the sister of marijuana, which is industrial hemp, okay? People get high off the female plant. And the male plant is used for fuel, fiber, and all other type of manufacturing products that would turn the state around. And you could probably take all the farmers north of Lansing, Michigan, and they could turn into bridge cars because they can grow industrial hemp and ship it back across the bridge back to Canada because we get 100% of our hemp from Canada. And we should give our farmers a fair shot at producing hemp and have real free trade instead of the crap. And that's real free trade. Now, I get a couple of complaints from my members about House Bill, was it 4834, with law enforcement having access to the registry. Well, my older brother's a cop too, he's been a cop about 30 years. I know a lot of Detroit police officers and just officers in general, and I think they do a tough job. They get a lot injured and fire people. They need, if they're injured, the injury, they taking opiates and they get, matter of fact, my older brother got shot at in Detroit by one of these mental people that got let out of a closed down hospital. And he's in chronic pain. He don't like marijuana, by the way. But you have to look at that. You have to look at the chronic pain and what marijuana can do. But the online registration, we feel that we need to put in we need to put in some type of barrier to stop law enforcement or abuse of someone to use that list as a probable cause search to harass and intimidate an innocent citizen in the state of Michigan using marijuana. Okay? I like to see that in the bill. I like to see online registration for patients too, because we're supposed to be a high-tech, go-go state. We got to show it in the IT world. Right now we're just weak. That's a great job to do with 27 days, but let's do it from the iPad. Okay? Other than that, like I said, my members are very concerned about this access to the list. And this 4856 is nothing but a cash cow, and it should be defeated and defeated now. Okay? And any question, like I said, I'm all about protecting the kids. They shouldn't be smoking K2. They should put them through the jail. Now, if I can go to the gas station and get K2, how come I can't get my medicine? Huh?
Well,
K2's not my medicine, but
it's
the
on the
principle.
governor's desk, and I think by July 1, you won't be able to get K2.
You'll be able to get K2?
You will not be able to get K2, I believe, by July 1.
Well, I appreciate that. Pastor Marva Winans would love you in Detroit, too, because he's totally against it. And what I'm fearing from Pastor Winans, he tried to equate K2 with marijuana. And, what the deal is that he got all these empty Detroit public school buildings, and to end the drug war, you're going to arrest more white people and put them in jails, converted Detroit public school buildings, everybody have a job. We can't do that. We got to we got to integrate it somehow to teach people how to grow. But that's why people are doing all the stealing. They're stealing plants. They should grow their own plants. Okay? They should grow, kale and all that other stuff. But anyway, I want to state my opposition to the bills. I hope you think about the patients. I always talk about free to weed. I know a couple don't like it, but it's about economy, creating jobs, Okay?
Okay, I appreciate your viewpoint.
Peace. All right.
See, no questions. Now, let's see. Senate Bill 4834, Senate Bill 4851, Senate Bill 4853, Senate Bill 4856. Attorney General Bill Schuette does not wish to speak, supports the bills. Yanko Restovic, Patients and Caregivers Organization, opposes the bills. David Brogan, Cannabis Patients United, is neutral.
Only on one bill.
On 4853. David Brogan, Cannabis Patients United, on 4834, 4851, 4856, opposes the bills. 4851, 4856, Noah Smith, Criminal Defense Attorneys, is neutral. 4853, Noah Smith, Criminal Defense Attorneys of Michigan, supports. 4834, Noah Smith, Criminal Defense Attorneys of Michigan, opposes. That's all the cards I have. We will review this over the summer with hopefully coming to a resolution in the fall. Thank you for attending. That will conclude the Senate Judiciary.
That's going to conclude the Senate Judiciary hearing today. And I missed some of what had actually happened. I'm going to clarify whether they are going to approve these out of committee or not. So we'll stand by for a couple of minutes and we'll get some clarification on whether these were approved out of committee, if they take it a vote. So apparently these bills are going to be considered throughout the summer. The chair has indicated that the Judiciary Committee is going to consider some additional amendments throughout the summer, and they will come back at this in the fall. That wraps up our live coverage of the Senate Judiciary Committee hearings on the House package of bills. Today is 6/12 of 2012. It is 2:27 p.m.